I'd love to tee up today's
Yeah.
conversation and then we'll get into it. Again, I'm Alex Beattie, divorce prep coach, the divorce planner. I love this Instagram series I have called In Conversation With, when I talk to a divorce professional. Today's guest is one very accomplished and notable guest, Chicago-based family law attorney and mediator, Kimberly A. Cook. Kimberly, as I mentioned, is also the founder and CEO of Grown Girl Divorce. She is, in addition to being a very well-respected attorney and mediator, she saw that there was a real need for a space to educate and empower Black women during divorce. So she founded Grown Girl Divorce, a platform that boasts a thriving podcast, coaching, free resources, you name it, she's got it.
Thank you.
So with that, welcome. And again, if you have a question about divorce mediation, please drop it into the comments and we will get to it as we chat through. I have a couple questions I'm just going to kick things off with, and then I'll go through the questions as I see them. So I think the big question for a lot of people who are just starting their education journey about a separation or a divorce is really, what is the difference between a mediation and litigation? If you could just give us some insight, that would be amazing.
Yeah, of course. Again, thank you so much, Alex, for having me on. I love chatting with you. You're always so great and fun to chat with. So this is always a really good time and to give information. I like to keep things simple because when one is going through a divorce, it's information overload and it can be very overwhelming. So when we think about, the difference between mediation and litigation, it really comes down to problem solving versus positions, right? So let's keep the P words in mind. Mediation is about problem solving, right? It's about everybody coming together, putting the problems on the table, and us collectively trying to solve those together, all right? In litigation, so that's going to be your traditional court process, we're talking about positions. And when I say positions, what that means is I am putting forth what my position is, and by the use of supporting evidence or testimony, right? I'm supporting my positions. And then I'm asking the judge to make a decision, right? So it's positional because it's your position, my position, and then a judge is deciding which position is really the one to go with, which is different than in mediation. It's here are the problems that we share, and here collectively we are going to solve those with the help of a mediator who is a neutral. And I'm sure we'll talk about kind of their role in a little bit as we go through, but that's really the difference. Problem solving versus position, and making sure you know where you fall when you're going through the process.
Perfect, clear. And I also love the fact that you really outline the fact that you have more control over the outcome when you go through a mediation, as opposed to putting the decision in a third party, like a judge's hands, to come to the decision.
Absolutely. And, the idea of control is going to be a consistent theme that you'll hear me talk about throughout this conversation, because it's really important to keep in mind who has control of the ultimate outcome. In mediation, because we are problem solving and we're trying to resolve a problem together, you're in control. When we are dealing with positions, your position versus the other person's position, you are no longer in control because you've now turned over the decision making to the court to decide. So mediation gives you that control over the ultimate outcome and resolution.
No, and I also love that it's a lot more cost effective, and you kind of get to go at your own pace with the mediation and set that calendar so that you've got some momentum, as opposed to, if you are going to go litigation, you are at the mercy of the court's calendar.
100%. I think one of the things that people lose sight of is a divorce is a marathon. It is not a sprint. And while it might be the center of your universe of what's happening, it is not the judge's center of their universe, because there are a lot of divorces going on at differing stages. And so people can often lose sight of the fact that the process is not going as quickly as they thought it was going to go, especially if you turn the matter over in divorce litigation. In mediation, right, it's we're coming together here. We're all going to set a date. We're going to, roll up our sleeves and really try to get out ahead of the issues before us. And that gives you so much more time to kind of work through things, but also you can, kind of say to yourself, I know we're meeting next Thursday and we're going to talk about the parenting schedule. It doesn't mean it may be fully and finally resolved, but you can bet that you are going to get into that session and talk about parenting and be able to at least start the conversation. That's different from having a court appearance on the calendar and thinking you're going to talk about the parenting schedule, and then you show up and the judge says, no, actually, I want to focus on the issues of communication that have now been brought to my attention, or let's circle back to the support issue. So it really does allow for you to have some sense of this is what's coming up, and these are the things that we are going to address during each session. Control, consistency, all of these great and wonderful things that people assume will happen in the traditional process actually happens in mediation.
I think, thank you so much for going into detail on that. I do see a question I'm going to get to in a second because it pertains to what I'm going to ask next, which is, what happens if two parties aren't getting along? Is it possible to mediate a high conflict case?
So here's the thing with high conflict. There's a difference between a high conflict case and a domestic violence case. Okay, so let me start by saying that, because safety is always first. Every case that is a high conflict does not necessarily mean that there's domestic violence or abuse. Now, that there's, ways to structure the mediation. But if we are talking about instances where there's an order of protection or no contact order, or there's been kind of physical violence, there is a very good chance that a court will set some structure and parameters if they are sending you to mediation. Keep in mind that mediation in large part is a voluntary process. And so you want to be mindful that if you are in a situation where domestic violence is present in your relationship, then my recommendation is that if you are interested in mediation, then you need to work with an attorney on like attorney assisted mediation, which is the process by which your attorneys are in the session with you in real time, one, and then two, if there's an order of protection or some other kind of no contact order in place, the mediator should be advised of same, because there are specific ways to structure the process so that we level and balance the dynamic. Because mediation requires that everybody is balanced and we are, neutral. And when we have issues of domestic violence, there is an imbalance. There's a power imbalance. And so as the mediator, they need to be well aware of dealing with that. So wanted to just address the idea of it can be done. You want to structure it. For high conflict cases, right? Those cases where we do not communicate well, we are not on the same page, we are been in and out of court. Yes, your issues can be mediated, but here's what it's going to require. It's going to require a level of maturity that not everybody has. All right. So we have to, be really honest with ourselves in terms of, am I coming to the table ready and able to participate in this process? That's the first thing. The second thing is high conflict oftentimes means that we are sitting in our positions. And I started out by saying this is problem solving. So you want to make sure that you are prepared to problem solve and not to come to mediation and try to reiterate your position. So you can mediate a high conflict case, but you really have to be ready to do so, okay? And know that, it's going to take a little bit more work because there's some communication and some parameters that we have to work within and work around, but it can be done.
So much to unpack in that fabulous answer. First of all, thank you for not only taking on high conflict and mediation, but also domestic violence, because that was a question that was dropped in. Is it possible to mediate when you have domestic violence? So thank you for that thorough answer. I think I want to kind of touch base. You saw me probably nodding and laughing along at you saying that, the point of mediation is really about having a collaborative conversation and problem solving. And that's something that I like try and get my clients in that mindset before setting them off on their journey. There's an emotional side to the divorce process, and then there's a business side. And you have to kind of time and time again, check your ego at the door, no matter which process you're choosing, but especially if you want to have a collaborative and an effective mediation. It is very tempting to not listen to what the other person's saying, to just want to get your point across. And that's going to not help create momentum, and you're not going to be able to actually have any forward movement without sitting with sometimes what the other person is saying, trying to dig down underneath to understand what that really is, figuring out. And by the way, this is so important to do, is to check in and say, what is triggering me about this? What is the thing, before you open your mouth, right? So I'm always like talking to clients about, take a breath, wait a beat, and you can always say, I'm not sure about that. I'll get back to you if you're really feeling triggered in the moment. And that's normal, by the way. Even in an amicable split, you're going to have that. So if you add tensions on with high conflict, it's going to take that much more practice in advance, which is like what it's worth every
penny.
Because of the pennies you'll save, and then you'll actually be able to be productive in the process. And pennies is a big thing to talk about with regard to mediation versus litigation. The average cost of a divorce through litigation in the US as of last year was between $15,000 and $20,000. And that's if things go well.
Yes.
Where mediation, you're talking about somewhere in the $5,000 average, which is a huge difference.
So let's just start by saying that it's a third of whatever the litigation cost will be. Okay. Because, and the way that I try to frame it out for people who always say, well, if I'm hiring a mediator, but then I might have to go and hire a lawyer, and I say this, in most jurisdictions, right, you're hiring a private mediator. That's one retainer for two people to help you problem solve and address the issues between you. And so if you come to mediation and say you have 10 issues, but you resolve 6 of those, right? So now we have 4 that potentially we have to turn over to the court or have lawyers kind of directly negotiate, right? You're already ahead of the game. But on the flip side, right, if you start out in the traditional litigation process, most people lawyer up, right? So I get a lawyer, you get a lawyer. All right. At a minimum, the retainers right now are averaging between 5,000 to 7,500. And these are not in big cities. I live in Chicago. It is, and I could say this honestly, I right now, retainers are like 7,500 to 10,000, and that's for amicable divorces. I know that New York and California are double that. And so if you both lawyer up, right, we've now spent $20,000 before the first thing has been filed.
Yeah.
That's dealing with amicable divorces. And right now, even the wealthiest people are being mindful about cost, because in the divorce process, it gets expensive very quickly.
Yeah.
So I strongly recommend that you really try to identify those areas where you think that you might be able to make some headway, to at least try to problem solve it, to see where you can get. It doesn't mean that you might not have to go to court, because maybe you will. But you have now said to yourself, okay, we've tried it. We work through those areas by which we could, figure out what works and maybe what doesn't work. And now we're ahead of the game. The one thing I tell even high conflict cases,
Mhm.
if you can agree on a mediator, that tells me that you actually can reach agreements. Whether you choose to reach agreements is a whole other thing. But the fact that mediation is a voluntary process in large part, and the two of you are here, tells me that you can do it. So now let's continue to choose to do it when we're talking about your family and your finances. So money, it's very cost effective, and it's worth trying to figure out and resolve those things that you can. And then other things that might need a little bit more, as I say, kind of massaging, well, you might be able to work through those even in the mediation process, but maybe those things require attorney assisted mediation, or maybe they require a little bit more time because we need external information. So all is not lost. It's worth the time and certainly the money of trying mediation before trying to litigate an issue. And I don't
I love
say that just because I'm a mediator.
Noted. And I think that, that don't get discouraged, right? Like if you are at a point where you can both agree on a mediator and mediation, if you have a little bit of conflict, don't be discouraged by that. Just know that some things might come a little more easily than others. Like I said, there are emotional reactions. Sometimes you're going to have to wait to get more information, so that that discovery process can take longer. And kind of going back to the cost of it, I say this from the high heavens all the time. The average cost of like a marriage certificate in the United States is $100, and yet the cost of like a divorce is like, if you litigate, is in good cases is 15 to 20 grand. The math ain't mathing.
The math ain't mathing. That's divorce math 101.
Is exactly right. So go in educated. If you're joining this chat today, I'm Alex Beattie, divorce prep coach, all about helping you financially organize, have goals and priorities going into the process so you save time and money. My guest today is Kimberly A. Cook. She is a top litigator. Well, are you doing litigation anymore?
I don't litigate anymore, but I did for the better part of 15 years, and then hung up my litigation hat and transitioned into mediation. However, those litigation skills are not lost.
They are not lost, please. She's ready.
I'm ready. I just choose not to litigate.
I love that. It's a quality of life choice for sure.
Yes.
So I did get a question that I wanted to drop in. Our Texan 12 asked, can a prenup be overturned? If so, can you give an example of cases? I'm not sure if that's possible, but go ahead.
Sure. So can a prenup be overturned? I'm going to give you the lawyer answer, which is, yes, but. Right. There are exceptions, right? And a lot of it has to do with how the prenup was initially initiated, if the parameters that were set forth in preparing the prenup, if those are laid out. And so it's not an easy feat to do. I will be very honest that overturning a prenuptial agreement is not easy, but it also depends on where you live, because some states have very specific rules and requirements as to what the burden of proof is in overturning a prenuptial agreement. What I can say is that there is a misconception and a myth that timing, right? So we signed it the morning of our wedding, and there were 300 people sitting, at the wedding, and because we hear that, and that's emotionally upsetting and it's overwhelming, but I can tell you that's usually not the reason that the court is going to overturn it. So if you're concerned about either signing a prenuptial agreement or you're in litigation as it relates to a prenup, make sure that you are working with a lawyer who understands here's what happened at the time of the execution, here's what the law says right now, and here's where things really didn't line up. So it can be done, but it is not something that is easily done. Okay.
So, great answer. So can be done with an asterisk. Thank you, our Texan 12, for the question. So, we went through a couple of things that I did want to dig into. Thank you so much about attorney assisted mediation. That was incredibly clear. What I wanted to ask you too is what I'm always hearing from you is like the 3 C's in mediation. Can you tell me what the 3 C's are?
Yeah, and we've talked about them, right? Collaboration, right? Cost effective and control. Okay, now I know people often think, oh, well, wait, isn't communication in there? Well, here's the thing, it's built into that collaboration piece, right? So I started out by saying I like to keep things simple. 3 is, easier than 4.
It's
But
the magic.
when we think, yeah, when we think about collaboration, right? In order to truly be collaborative, you have to be able to communicate and communicate well, right? And so mediation requires the ability to work together in coming to a resolution that doesn't just work for you, but it works for everybody. And that can be very difficult for people to, kind of massage that muscle, right? Because we are really interested in kind of, this is what I need, this is what I'm interested in, this is what I think is best, when in order to really reach a resolution, this will work for everybody. We've talked about the idea of cost-effective mediation as a cost-effective process. Even if you don't resolve everything, I've had families that come to me for the parenting matters, and then they need to otherwise litigate the finances. I've had others who dealt with finances in mediation, and they were in litigation on parenting. But it's a very cost-effective process at any stage, and I want to underscore that mediation can be done at any stage of the divorce. So before you file for a divorce, if you are in the active divorce process, and even in the post-judgment process, you can mediate. And then, of course, the idea of control, and control being, the mediator is the neutral. They are there to facilitate the process, to referee if needed, to help you think through things, but they are not the final decision maker. In order to reach a resolution, the two of you do that on your own. And by on your own, meaning the mediator is there to support you, to answer questions, not give legal advice, but you have control over the ultimate outcome. So those 3, collaboration, cost effective, and control, are my 3 C's of mediation.
It's perfect, so clear, and kind of jumping back to the process for people who are kind of just educating themselves now. What you have to remember, is that divorce is one big negotiation.
Yep.
It's a negotiation of, if you have kids, parenting time, it's a negotiation of splitting up assets. It's so, and so on and so forth. And I think for a lot of people, they're not comfortable with negotiation. It might not be a part of their everyday life, whether it's their job or just their interactions day to day. It is something that you want to kind of prepare yourself for, because it can feel personal, and it's not. I do have a blog post that I just put up, 6 tips to get you prepared for the negotiation process so you really succeed. And it's up on the blog for anybody who's interested. So I know we've already been talking for 25 minutes. This is our quick little day snack of a conversation. So I'm going to wrap it up in a second. There were a couple of questions dropped, and then I have one last question to wrap it up if you have another minute. Amazing. So A Singer 817 said, can you still go to mediation after seeing an attorney?
Yes, you can. Working with an attorney and getting information, because keep in mind, the mediator is not your attorney. So even if they are an attorney, right, by education and practice, they're not your attorney. So a lot of people will work with an attorney throughout the process, even if the attorney is not engaged in the process. So absolutely, mediation is always an option, whether you are represented or not. Also keep in mind that every mediator, even in divorce and family, is not an attorney. There are many therapists, there are many financial advisors who also are trained as mediators. And so it can be helpful, especially depending on the issues that you are addressing in mediation, to speak with an attorney as you engage in the process. But yes, you absolutely can.
such wise words. I actually have a freebie, 24 questions to ask a divorce attorney or a mediator. It's a jumping off point for people who are trying to educate themselves in advance of taking these consultations. It's a freebie. Like I said, download it through the link in my bio. It's going to get you thinking more in terms of what you want to ask, because when you're choosing somebody as well, and I love that you pointed out that there are a couple of different types of mediators, different backgrounds, right? I always advocate for my clients, if they're financially in the position, to have a family law attorney consulting on their behalf, because as you mentioned, a mediator is acting as a neutral third party. They do not represent one spouse or the other. They're really representing the divorce process.
That's right.
Yeah. So great advice. And sometimes, unfortunately, you have to be in a position having that person perhaps that you met with. If you are moving forward in good faith with mediation, you decided on a mediator, but you say, you know what, I'm just going to consult with an attorney to look through all the details of our notes. Am I missing anything? Because unless you are an attorney, you don't know the law, right? Like,
you do not.
It's what it is. And look, I know I don't have to tell you this, but reading through those documents is like reading routing instructions. Like, if you are not familiar with legalese and all of that stuff. So if you are in a position where you can have a consulting attorney, fantastic. And then worst comes to worst, sorry, the shit hits the fan, you have somebody who could potentially litigate, and you don't have to get them up to speed. So, you know, you don't have to engage them all the time, but you got them on the bench.
Yes. And you know, you've found a relationship and somebody that you're comfortable with. 100%. Listen, I know lawyers who also consult with other lawyers through the process. This is a very difficult process, and things don't always kind of make sense in the way that you think it was, especially in divorce and family practice. So it is always advisable to consult with a divorce and family attorney, especially if you have questions. Do not rely on, you know, your Google research solely, because everything and is state-based, and it's really important. You know, what may work in Illinois will not work in New Mexico, will not work in New York. And so it's really, really, really important that you connect with somebody in your area to make sure that you truly understand rights, responsibilities, and the laws in your area. I cannot stress that enough.
Absolutely. And just because also, even in your area, just because something worked for Aunt Mary or Uncle Joe, it doesn't mean it's going to work
You're
for
right.
you.
You're right. No. Every family, every circumstances, everything is like your fingerprints. Every situation is very unique. And you have to keep that in mind. You can hire the same lawyer, you can be in front of the same judge and have a very different outcome. So things are unique to you and to your family. Give yourself grace in knowing that. But realistically, know that your process is your process, right? And you want to be able to make good decisions about your individual process. So, you know, put on those kind of blinders, right? And don't compare with what others have done or what how their process went, because it will be very different than what your process is. Very, very true.
True. I totally agree. So I'm going to wrap this up with one last question that actually pertains to, if people say, oh my gosh, I'm going to grab that freebie, 24 questions to ask a divorce attorney or mediator. Okay, that's just part of the process. The other part is like, Kimberly, what should people be looking for when considering hiring a mediator?
Yeah, that's a great question. So here's there are a couple of things, right? As I referenced, every mediator is not an attorney, and that's okay. But you should make sure that you are working with a mediator who has an understanding of the subject matter that you want to address in mediation. So, for example, even if someone is a divorce and family attorney, they may not mediate or feel comfortable mediating complex financial issues. If you're working with a therapist or somebody who's a financial neutral, they may say, hey, I'm not comfortable dealing with the parenting. So the first thing you want to look for is making sure that somebody understands the subject matter by which you want to address. Do not assume. You also want to connect with somebody who is responsive to you, and responsive meaning, no, they're not going to be responding 24 hours a day, 7 days a week. Everybody needs a moment. But, if you've sent a couple of messages, to better understand their process and you haven't heard back, then you might want to say to yourself, maybe I could connect with somebody else. You certainly want to, connect with somebody who is trustworthy and has some credibility. And when I say some credibility, what that means is if you get a referral from friends and family on some level, that means that they have been vetted in some way. Take note of those things, right? If you find somebody who's listed, on the internet, that doesn't mean that they're not a good lawyer, but I would say do a little bit more digging. If they are a lawyer, check and make sure, that their licensing is up to date. Mediators don't require certain licenses in every state. However, if there's some negative kind of history as it relates to their law practice or, therapy, issues in terms of how they work and how they practice, take note of those things. But you really want to be mindful of connecting with somebody who can be neutral. And I think that's the most important. Finding somebody who can listen to each of you and help facilitate the conversation without leaning one way or the other. This individual is a neutral. They do not represent you. They do not represent the other person. And you want to keep that in mind. And so you want to make sure that whoever you're working with is communicating to you at arm's length, that is respectful, but that you feel very clear about their ability to maintain a level of neutrality. It's really important.
That's interesting. Actually, I didn't expect you to bring that up. I know we're just wrapping things up here, but I have a question. So then if you are mediating with somebody and you have a conversation, both parties bring up different points, different positions on something, go away, and then they come back and they say, you know what? I think so-and-so is right. That's not good.
When you say, I think so, the mediator coming back and saying, I think so-and-so is right.
Yeah.
So here's the thing. It should be more of here's my understanding of where, of what they're offering up or what they're proposing, right? Mm-hmm. Here's what the law says, or in consideration of some of these things, you want to keep in mind this. Now, there are situations where you have to be able to acknowledge a fact. So for example, if someone says, I never got the login information from the school or whatever it is, right?
Yeah.
And you're in the mediation process. And as the mediator, right, I know because either your lawyer has sent me some information or somebody has exchanged something that says you in fact receive it, mm-hmm. then it's on me to say, actually, based on the information that I have received, that is consistent with the information. So it's all about how it's relayed to you. The difference in when I say somebody being neutral is you want to be mindful a couple of things. One, if there is a prior relationship between the mediator and one of the participants, mm-hmm. that should be disclosed.
Got it.
Right? So, it's, I knew your cousin, or I knew your brother, or we hung out at a party, even though we didn't know each other. You have to bring that out. That's one. Two, if there is a mediator who, is kind of, ready to kind of be a hothead, and there are people who, they cannot maintain an even keel, you got to be mindful of that, right? That's not their role. That's not their job. So making sure that the person that you are engaging with, the mediator that you're engaging with, is truly a neutral and is able to maintain that level of neutrality for everybody. It's really important.
Such great information today, Kimberly. Thank you so much for joining me. I so love our conversations. You're always so generous in your knowledge, and I hope to do it again soon.
Yes, me too. Thank you for having me on. I really appreciate connecting with you as always in this new year. And so, thank you very much for this time and opportunity. It's always great to chat with you. It's my
pleasure. And thank you to everybody who joined us. We'll see you next time.
Yes, thank you.
Bye, everybody.